Ms. Hartman, you ready to answer Mr. Treasurer's question?
I am. Thank you, Trevor. Thank you, Mr. Black. Good morning, Treasurer and Benchers. It is my pleasure to present the Compensation Fund report, which you will find at tab 7 of board books. And at tab 7.1, you will see the motion. And today, the Compensation Fund Committee is recommending that we set a new limit for the per claimant provision, and that it be $500,000 per claimant. If approved today, we will need to amend the guidelines to reflect that new amount of $500,000 and its start date as today. Any change to the limit will only be a prospective change rather than a retrospective change. To remind everyone, the reason we have a compensation fund is to relieve hardship for clients who have suffered a loss due to a lawyer or paralegal's dishonesty. The compensation fund is needed because our E&O insurance does not cover theft, does not cover dishonest conduct. It only covers negligent conduct. And so typically the types of claims that come before us at the committee are where a lawyer or paralegal has absconded with a client's monies, either monies that have been held in trust for a retainer, monies held in trust as a result of a settlement of a claim, as a result of an estate, or as a result of a real estate transaction. We decided that it was time to review the per claimant limit for lawyers because the last review was in 2008. And given that the limit is only at $150,000, given the fact there hadn't been a review in some 8 years, we deemed that this was a necessary exercise for our committee. We've decided that it's not necessary to review the paralegal per claimant limit of $10,000 because typically the claims that come before us are for generally small settlement amounts or small unearned retainers. So when we say the per claimant limit is currently set at $150,000 and we were asking for a new limit at $500,000, what we are saying is this is the maximum amount that a client can hope to recover because of a lawyer's dishonest conduct. It is a cap. And as Mr. Brett has indicated, the use of the funds are totally discretionary. And it is up to the committee to decide whether or not to grant some or all of the claim. And to my friend's question, I believe that we are paying out at about 50%. Sorry, I would like to introduce you to, and I should have earlier, to Dan Abrahams. Dan Abrahams is the manager of trustee services and compensation fund. So Dan, you will have the more detailed answer, so if you wouldn't mind sharing it with us.
Thank you, Madam Chair, Treasurer. The largest group of claimants are paid out at 100% of what they can prove they lost due to a licensee's dishonesty. The claims can be reduced in a number of limited circumstances because they include amounts that are not covered, for example, according to the guidelines, damages, interest, or costs, because of risk or carelessness on the part of the licensee, or because they exceed the applicable limit, currently $150,000 or $10,000 for paralegal dishonesty. That's actually a very small amount according to the materials that Convocation has received. Most claims that we receive are actually under the current limit, and that would continue, obviously, when the limit is raised. Thank you.
Thank you, Mr. Abrahams. So as part of our review, we looked at the fund's claims experience. We looked at information from other provinces, as well as we looked to the US. Now, within Canada, we acknowledge that it is difficult to compare apples to apples because outside of Ontario, in the provinces and territories, the number of lawyers practicing is considerably smaller than here in Ontario. However, with that said, we, as a committee, are cognizant of the fact that in British Columbia, their per claimant limit is $300,000. And in Alberta, before they went to an insurance model, they had no per claimant limit. We also reviewed a survey conducted by the American Bar Association, and it had a wide range, anywhere from $50,000 to $400,000 per claimant. We also retained an actuary, and they were Eckler consultants, and we asked them to provide to us the impact on grants paid if we do set the new limit at $500,000. And for that exercise, Eckler's looked at data collected from 2000 through to 2014, and they also considered that historically, the Law Society pays out at the 50th percentile. That is what we seek when we are doing our annual budgeting for provisions. We look to the 50th percentile. And so what Eckler's discovered is that the average of the results at the 50th percentile at our current limit of $150,000 means we would need to budget annually $3.1 million. And that would be a levy of about $272. If, again, looking at the 50th percentile based on the data collected, we are of the view today that the new limit of $500,000 is appropriate, then this will mean that we will need to budget for 2017 $3.7 million, which will be an increase of about $15. Means our levy would be at $287. So about a $15 increase. Now, I need to draw to your attention, in case you are not aware of it, the fact that all of the levy is not merely applied towards paying out claims. In fact, a portion of our levy goes to cover certain administrative expenses. It goes to cover spot audits. It goes as well to cover some of the costs associated with the Society's investigation and discipline functions. And as we heard from Mr. Brett, we also look to its reserves to reduce our members' fees. And in fact, over the years, and I know that Mr. Groya, and I believe he is participating by phone, will correct me if my memory doesn't serve me properly, but I think over the years, we looked and took from the compensation fund reserves somewhere between $7 to $8 million to reduce lawyers' fees. I suggest to you today, Ventures, that had we not done so, there would be no need to increase the levy to meet the new limit of $500,000. As I stated earlier, the per claimant limit will only apply to funds advanced to lawyers as of today if Convocation passes the new limit today. The committee was and is unanimous in its recommendation to set the new limit at $500,000. Now, I can tell from the expression on some of your faces that not only have you read the materials, but you understand the materials. And you are probably asking yourself, given that the vast majority of the claims fall well below the current limit of $150,000, and given that according to our actuaries, this will continue to be the case, even if we go to the new limit of $500,000, you're probably asking yourself, well, then why are you here asking for the new limit? Well, the answer is very simple. We have said repeatedly that our core mandate is to regulate lawyers and paralegals in the public interest. We are here to protect the public. We have also said repeatedly, and especially over the past 2 years, that as a law society, we want to be a leader as a professional regulator. We want to be ahead of the curve. We want to be the law society that sets the example, that sets the standards nationally and internationally. Well, benchers, today is the day. Today is the day for us to walk that talk. Setting the limit at $500,000 will clearly serve very well our public protection mandate and our leadership role as a regulator. We will be signaling to everyone that the Law Society of Upper Canada, as a leading regulator, gets it. We fully appreciate that there must be access to appropriate compensation if you suffer a loss because of a lawyer's dishonesty. That's why we are here today requesting the new limit. The motion, Treasurer, is found, as I said, at tab 7.1. It is moved by me as chair of the Compensation Fund Committee, seconded by my friend Chris Brett as chair of the Finance Committee. And as Mr. Brett has already alluded to, in the proposed budget, it is based on this new limit of $500,000. So, benchers, as I said, today's the day. We need to walk that talk. And just as the decision was unanimous at committee, I'm hoping it will be unanimous here at Convocation.
Thank you.
Treasurer, those are my comments. I'm happy to answer any questions. I do want to recognize my committee, if I may. Vice Chair Michelle Haig, Joseph Groya, Jan Richardson, Giselle Chrétien, and up until just last month, Catherine Strasberg.
Thank you very much, Ms. Houghton. Ms. McGrath, you wish to say something?
Thank you, Treasurer. First of all, let me preface what I'm going to say with the fact that I support this motion as the past chair of the Compensation Fund. But I do want to actually give a note of caution. When we say that the grants out of the fund are totally discretionary, we are holding ourselves out to the public as protecting them from lawyers' dishonesty. So the times when we would exercise that discretion, I suggest to you, would be few and far between. So I just don't really like the fact that we say it's totally discretionary. Frankly, I don't think it is. You know, for the benefit of the profession, for the benefit of the public, most of the claims, they fall within the parameters, are going to be accepted.
Yes, Mr. Sharp.
I'm probably one of the ones that was a bit perplexed by your suggestion. If the facts are that vast majority of claims are under 150, and that's what's to go ahead, then despite the issue of leadership, I don't see how we're showing any greater leadership by increasing the limit. I think we have to be fiscally responsible. I don't disagree. We are here to protect the public, and for a vast amount of time we do that. I would say that if you have discretion, I don't know if you have discretion to go beyond the limit, but maybe a resolution might be that on a case basis, if somebody comes in and legitimately has been wronged over 150,000, that maybe that's the amendment you need to make to allow you to go up to 500,000 on a case-by-case basis. But I don't see how carte blanche going to 500,000 helps it. So that's my vision of it.
Yeah, if I may, Treasurer, I'll be frank. When the committee was looking at this, we were quite frankly embarrassed that being the largest law society, our limit was only 150,000. And We were also extremely cognizant of the fact that more and more, especially with respect to real estate deals, the losses are significant. Right now, I can tell you that there will be one claim based at the one, if we keep it at $150,000, their loss will be more than $650,000. So we were very cognizant, especially in the real estate world, that the claims are larger and the losses will be significant.
Thank you. Mr. Wright?
Thank you, Treasurer. I also speak as a former chair of the Compensation Fund, and it was on my watch that it went from 100,000 to 150,000, and at the time I said I didn't see why we needed a cap at all. It's an entirely discretionary fund, and now we're going to fetter our discretion. I don't see any logical reason to fetter that discretion when the committee, the Compensation Fund Committee, can authorize an award of any amount in its absolute discretion. If we really want to walk the talk, then we should do what at least one other jurisdiction has done, and that's remove any cap at all. If a lawyer has been dishonest and the client can prove harm as a result of that, and it turns out to be $650,000, then by golly, that's what we should pay them. If we have to, at some point in the future, amend the compensation fund payment that every lawyer makes, so be it. If we're here to protect the public, then we have to walk that talk all the way, and not by setting, I was going to say, artificial caps. Even if it's a cap that's so high that it'll hardly ever be exceeded, there should be no cap at all. And for motion to 2A, it also says to apply only to claims from today going forward. I think it should apply to any claims that are already in the hopper. Why should somebody be harmed simply by bad timing? And especially if we don't have a cap, there's no need to deny anybody a fair payment if they have been victimized by dishonest lawyers. Thank you.
Thank you, Mr. Wright. Firstly, with respect to why it is only prospective rather than retrospective, is because historically that is how it has always been applied. So even when you agreed to a new limit at 150, it was only going forward. We discussed no limit. Again, I'll tell you candidly, the committee was of the view that there's no way that this bench would pass an amendment. So
That doesn't mean you shouldn't.
I agree. I agree with your comments.
Thank you, Mr. Lerner.
If I might, from my place, I'm just looking at page 491 in the chart. Is 2014 and 2016 the aberration, or is it 2015? And is there an explanation?
My board books just died. Mr. Abraham's committee. Thank you, Mr. Wright. I'm sorry, Mr. Lerner, can you please take me to the page again?
491, the chart, second line, 2014 and 2016 seem comparable. 2015 seems double any amount. Where's the aberration?
It's 2014 and 2015 are indeed the aberrations, I'm told by Mr. Abrahams, and that's because of the number of new claims that have come in.
But I guess the question is, why is it double in that one year than any other year that it appears on the chart?
Go ahead, Mr.
Sorry, it's 2016 to date.
Yes.
2014 and 2015 are standard. Sorry.
You're only looking at half a year for 2016.
We're only
Well, I
looking at half a
appreciate
year.
that, but even if it's half year, it's about $17,000 or so for the full year. Yet 2015 is 34.2, and the other years are around 17 or approximately 17.
Which line are you referring to?
2.
Line 2. Yes, 2014, 2015 was a particularly high year. 2016 to date, it's impossible to predict where we will be at the end of the year. We may have had a flurry of claims mid-year. The fund is not large in terms of the number of claims it receives, and so there can be wide fluctuations from year to year, even from month to month. So we don't see any particular aberration this year.
Are there any other questions or comments in the room, Ms. McGrath?
If I could make my comment from here, I think part of the problem is that the claims may come in 2014. That doesn't mean they're actually dealt with and paid out in 2014, so that you had more payments out in 2015, but that doesn't mean that's where most of the claims came from originally.
Thank you, Ms. McGrath, and if there is the new limit today, we don't anticipate receiving claims for Mr. Abraham's, another year, 2 years? Year and a
Could
half?
receive one tomorrow, but most of them will come in years to come.
Any questions or comments on the telephone? We could go out of lecture.
The conference is no longer in lecture mode. So I
Thank you. No comments or questions on the phone. Given that, then we'll put it to a vote. Thank you, sir. No, just shaking your, just throwing your.
Getting ready to vote.
Thank you. All in favor?
It was a false start.
Any opposed? One opposed in the, 2 opposed in the room. Any opposed on the telephone? Okay, the motion is carried. Thank you, Ms. Hartman. All right.
The conference is in lecture mode.
Thank you, Mr. Abrams.